Right, welcome back to another episode of Justice for Y'all. I'm Paul Painter, and with me, as always, Andrew Bowen and Stephen Morrison, who have switched around their seating a little bit today.
Well, I've got to run this technology with my my now aging title of Chief Technology Officer. So these graphics don't do their own thing. You got to have somebody here manning the station.
That's right. For those who are not watching it, we've got our logo up on the TV screen here, and we're looking really high class.
Oh yeah, we're a professional outfit.
Yeah,
we even had a guest on that TV at one point, which is when I started sitting over here because I was really.
That's right. Yeah,
that's like Andrew had to move over.
We were talking yesterday how we're really podcasters first and lawyers second.
Yeah,
at this point in our career,
it's taken over our life.
The entertainment careers are really taking flight.
We're influencers.
Yeah,
obviously,
we're definitely influenced.
I don't know what we influence, but we influence.
Yep, that's the world.
Yeah,
that's clearly the world.
Clearly,
Joe Rogan, look out.
Yeah. He keeps calling, and I just haven't had time.
Well, we should probably do him a favor and let him have a guest spot on the podcast.
Nice,
a couple minutes.
You're welcome anytime, Joe. Come on.
You're tuned into the podcast where justice meets Southern hospitality. Broadcasting directly from Savannah, Georgia, join your hosts, Paul, Stephen, and Andrew of Bowen Painter Trial Lawyers as they chat about the legal difficulties you might face in everyday life. From the ports of Savannah to the busy highways that stretch through the Southeast, we're your go-to source for all things legal. Served up with a dose of Southern charm and commitment to justice for y'all.
So before we get into our topic for today, which is going to be a series, we're not sampling it now because we're in the morning, but yesterday afternoon we sampled a bourbon.
Yes, we did.
And Stephen, tell us a little bit about our bourbon.
Yeah, so we went with a Smoke Wagon bourbon. They are out of Nevada, and I think Las Vegas distillery out of. So it's a Western distillery. We had the uncut, unfiltered. So there's a couple of different ones, and it was pretty solid. Now I tell you, I've had a couple of Western whiskeys. The other one that I like is High West, which is a Utah-based distillery. Mm-hmm. Their double rye is good and is kind of something more everyday. It's not too expensive, not cheap, but not super expensive. But the Rendezvous rye, that one, it's a really, really nice whiskey. But
that was a good bourbon last night. I have to say, I was skeptical coming out of Las Vegas. I was like, I'm not sure.
I know.
It's like we trust you, Stephen, but we'll see how this goes. But it was really good. And it's spring now, so I think I don't know about y'all, but my bourbon drinking goes down when the weather.
It's definitely a cold water beverage.
So it was a good one to break the fast, so to speak.
It was, yeah. I enjoy. I've been wanting to try that one. My brother-in-law has mentioned it to me, and I consider him an authority in my sphere of influence when it comes to these things. And
it's high praise.
It really is. I mean, he's one of the folks that I consult on these things, and he talked about this one, and it delivered. It was really good. And they've got some cool bottles too. We could have brought the bottle, I guess, but just some nice look to it, kind of knobbly, and it's cool.
Yeah. Well, let's get to the topic of the day and the topic for the next few episodes. So what we're going to do is talk about trial and the phases of trial that most people listening, lawyer, non-lawyer, are going to be familiar with that you see on TV. But we're going to go into a little bit more depth and talk about what each phase is all about, and from a lawyer's point of view, the court's point of view, what we're doing in all these things. And so the phases I think we're going to talk about are going to be voir dire, the jury selection.
Pronounced in Georgia as voir dire, pronounced everywhere else as voir dire.
Voir dire.
Voir dire.
Yeah. When we go out to California, I say, we're going to voir dire the witness. They're like, God, this country come to town.
Well, we'll have, clients from up in the heart of God's country up in North Georgia. And so we got to put on the show there now that we're entertainers primarily.
That's true.
I mean, that's
a good point.
What are the people? And we'll be in Hollywood, so
yeah, well, that's true.
For all these reasons, it's voir dire.
And so then we'll do opening statements. We'll talk about the plaintiff's case in chief, the defendant's case in chief, and then closing arguments. So we got a few episodes here to.
It'll be fun.
Get all that stuff, broken down.
I think we've talked about voir dire in another episode, but not devoted a whole episode to it. Stephen, it's a French term, correct?
That's my understanding, yes.
That's why we didn't get the Latin.
It's exactly why I
little chime.
did not get the Latin chime. I mean, Latin or French is a Romance language, so I'm sure there's roots in there.
So what you're saying is we just need to. That's
the French.
Yeah, that's for the French.
Keep going. We'll find it eventually.
If only we had something available just at our fingertips, we could look up information about different topics.
I tell you, if somebody
One of these days.
invented a website or something, you can ask questions on.
So here's what the AI says. It says voir dire means to speak the truth in French.
And it's the whole, and you'll see it. That's the whole purpose of it. I mean, the jurors, when they come, they are under oath when they're answering the questions, at least on the jury questionnaire, or they have to affirm that what they're saying is true.
So let's get some context to it.
Yeah. What is voir dire?
Okay, so voir dire is a phase of trial that I think most lay people would consider jury selection. And that's a bit of not a very good term for it, because as lawyers, we don't go in there and pick the jurors we want. The purpose of voir dire, jury selection, is to eliminate the jurors who you don't want on the jury or who are not qualified for some reason to be on the jury. So what we're doing is we're striking jurors, the potential jurors. There's so many out there, and then you strike them and then you wind up with a jury of either 6 or 12, whatever your goal is for a jury. So voir dire is the process, sort of how it works. Let's kind of just walk through the mechanics of it. It can be done by the court itself, which we'll talk about in a minute, or more commonly, it is done by the lawyers for the parties. And the jury, you come in, the start of the trial is the court will come in, the judge will come in and call the case. Is the plaintiff ready? Ready for the plaintiff, Your Honor? Is the defense ready? Ready for the defense? At which point if you have any motions or anything like that, you'll deal with them. But then they'll bring in the jury panel, and the panel is when you show up for jury duty and you get selected to go to one of the courtrooms, they'll take you to some pre-staging area and usually show a video of how important jury duties is and yada yada yada. Then they'll take you into the courtroom, and different states do it different ways. The way Georgia does it, which I think is fairly common, is they will bring in the potential jurors and sit them in the pews, back where the audience would sit for during the trial. And so we will all turn around and face the audience, so to speak. Then and we'll get into some details about that in a second, but then the attorneys will take turns. The judge will qualify them first. They'll qualify them to the parties to make sure nobody is related to a party or knows them, anything like that, because that's an automatic disqualification. And then anybody else who has a financial interest in the case,
right,
which is, the defendant does, the plaintiff's lawyers do typically, because we have a contingent fee arrangement. And sometimes the insurance company, for instance, State Farm is the people who have State Farm auto policies have an ownership in the company.
Because it's a mutual company. It's owned by the insureds.
Right. And so anybody who has State Farm insurance, if State Farm is the insurer for the defendant, can't serve on the jury, which is a lot of people typically.
Before this group of potential jurors comes in, and sometimes that is called a venire, and that is a Latin word.
Yes.
Yeah, that is a proper Latin word.
Venire in Latin means to come, and so in the legal judicial context, the venire is the group of jurors who've been summoned to come to court to potentially serve as jurors. But before they come into the courtroom, they have been qualified just to make sure they're legally qualified. They're citizens of the county of Chatham. If we're here in Savannah, they have to be a citizen of Chatham County. If they're over age of 70, that's an automatic. They can still serve if they choose, but they can get out of jury duty just by saying, "Hey, I'm a senior citizen. I'm over 70. I don't have to serve." So there's some other things like that have gone on before they even come into the courtroom to be questioned. But then, as Paul was saying, the judge asks some basic qualification questions, looking for legal bias, and then it's turned over to the plaintiff's lawyer.
That's right. And the plaintiff's lawyer, because the plaintiff has the burden of proof, gets to go first in all things.
Or in a criminal case, it would be turned over to the state at that point.
Who would have the burden of proof to proving the person guilty, right? So,
let's talk a little bit. Like, what do you? We've turned around now. The lawyers are all facing the bench. We've turned around, and what are we looking at, and how are these people arranged before us? I mean,
how do we identify them? This is one of the hardest things to do in trial. Just because of the logistics of it. So,
every court seems to do it a little bit differently too. So.
Every judge, court. I mean, you've got what we are talking about now is largely geared towards Chatham County State Court, but this happens at state, federal. It happens, state superior, the different judges, different courtrooms, and then different states will have different practices. I mean, you can really
talk about California in a second. Yeah, there are some difficult
peculiarities.
Right. So what we have to do is we have to track who are these jurors, and we have both their name and their juror number. And the juror number is key because that's how the court is tracking them. And that's if you were to appeal the case for some reason, you need to be able to identify the juror number.
And typically they're lined up, 1 through 12 on the first bench, 2 through
13
through 24.
That's why it's so hard.
Which is the next.
But the benches aren't always the same length. So sometimes you'll have 1 through 10, 11 through 20, and then you just have like 4 in the next one. And so we would try to get a juror list ahead of time. That used to be easy in Chatham County. You used to be able to get it a week or so ahead of time, like the people they're going to call in, which would allow us, if we were so inclined, to do jury research because you understand what do people put on their Facebook, that kind of whatever is public. Figure out who folks are, so you say, are they good for our jury or not? That is becoming less common here, and I think other places too. Now we don't get the jury list until the morning of trial. The one good thing about that is if you get it ahead of time, not everybody shows up for jury duty. So, you're not going to have the right numbering, you're not going to have the right people, and the research you do is kind of hard to put into a way you can use it in the courtroom. Though some people do get jury consultants who, that is their job. They look in there and sort of advise whether a juror would be good for the case or not. I've never used a jury consultant. Have y'all?
Not a jury consultant, no. Sort of the mock jury thing, but not what you're describing as sort of a PI who does, background research and builds almost a
dossier.
The dossier, yeah, exactly, on each of these people. No, I haven't worked with them.
Yeah, that people do, and I'm not sure there's any magic to it or not. Your jury is obviously very important because the people who wind up in your jury are making the decision. So you don't want to have people who are unfriendly to your cause.
And you want to know where they come from. I mean, there's a lot of points to jury selection. Obviously, the goal is to get to a jury so you can get the case go forward and they can decide it. But understanding your audience is key to any presentation. I mean, even ultimately, we don't get to, like you said, to pick, we want these 12 and these 1 or 2 alternates, and that's, we don't get to pick that. We get to influence that through some of the strikes we'll talk about, but at the end of the day, you may all that you get to do is you just get to understand a little bit more about where does this particular group of people that have ended up on my jury, where are they coming from? What kind of experiences are they bringing to the table? What concerns have they raised? Then how does that fold into what I've got to present to them at trial? So you want to know your audience and understand. And
the best way to do that, I think most trial lawyers agree, the best way to do that is to get the jurors to talk. And so we want to identify biases one way or the other. We want to identify things that may make them identify with our client in our case more than others.
Well, before we get into that, because that's the key part of it all, is really, but let's talk about the logistics on how we track those, because I think it's pretty interesting and some lawyers want to hear about it, at least.
You really think that's interesting? You're so nerdy.
I really am.
I mean, he's getting nerdy. He's talking nerdy to us. This is what our listeners have come to expect.
Yeah, that's right. Hi, Mom. So the way you used to track it, or the way most people still track it, is you get a manila folder, which is like a legal size folder, and you open it up so you have a big platform to write on. Then you get a ruler and you create boxes for where all the jurors are. And then you put the jury number and name that you've just gotten this sheet that says where they are into this box. And as the jurors answer questions and say things, you take notes where in the box where they say it, so you can track what people are saying. Now, you sometimes have 50 people in the veneer, so like you've got to.
The veneer is the veneer or the veneer, yeah, not to be confused with the thing on top of a nice piece of wood.
Yeah, sorry.
No, I call it the veneer too, and I'm sure it depends on where you come from, but just that's the same word that we're using here. Yep. Veneer, tomato. Voir dire.
Yeah. So this is such a confusing part of the trial. Nobody even knows how to say the word. There's not even a consensus there. But anyway, so you track them like that. So what we've started trying to do recently, I've been looking for years for a good app to use, because it's hard to ask the jurors questions and take notes and be able to think, how can I go back and use those notes in a way to...
And it's all happening very fast. I mean,
very fast.
It just is... It's so hard to keep up.
Yeah.
Even though it takes sometimes feel like forever to select a jury, the information is coming from so many different places, and then you have to use that. I mean, we'll get in with the judge. I mean, it is very important to track this by number, get it accurate, and you have individual questions and you have group questions. So,
what's the name of the app, Paul?
Yeah, it's Jury Box. And we just used that at a trial we had not long ago, and we really liked it. The one thing that it does is it allows you to put those seats in the order that you want them. But if you have a paralegal trial, which we typically try to do, you get the jury list in and she can start putting the names in, typing it in, and your devices talk. It exchanges the information. So if I take a note on a juror, if Stephen's trying with me, he's going to see that pop up on his too. And you can select the juror on this app, on their seat, and it'll pop up all the notes. But if you can put emojis in there, the emojis will show up on as you're just looking at all the seats, all the jurors sitting there. So you can kind of quickly know if this is how they answered one particular question. And what we did in the last one is we didn't really prepare for this as much as we normally would using technology. We had Andrew in the courtroom doing it the old school way. So, if this didn't work, we would have a backup. But we didn't prepare what emojis we were going to use, and trying to do that in real time, it was the things that pop up. And we'll talk about moving to strike someone for a cause, but we had the middle finger emoji was that one. So if you want somebody struck, not good for your case, middle finger emoji, and it would just sort of stay there. So anyway, it's a really neat app. For those who try cases, check out this app, Jury Box. And also, we're talking about different setups. Like in California, they typically will put 14 jurors in the jury box. There's usually 14 seats, not for 12 jurors and 2 alternates, all in the jury box. And then you talk to the people in the box, and then as people get struck, new people come and fill in.
Right.
Which is really confusing, because now you got to ask your questions again to the new people. And, some people just sit there the whole time. So it's this kind of drip, 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 and that's why it often takes 2 days to do that.
And that's compared to like here in Georgia, where it would just be, you've got your group of 40 to 50 in the veneer, and you're asking the questions, then you do your strikes from each side from a subset of those that you've identified. Once we apply all the strikes, after all the strikes for cause have been done, there's a little bit of math involved. We should maybe talk a little bit about how that happens. But it's different than you got 14 people and they're constantly sort of falling out versus you've got a group of 30 to 50 that ultimately
are doing it
all
they're all
once.
talking at one time. Quick, before we go on to the questions we ask and why we ask them, we should talk about some courts, like federal courts. The lawyers do not do the voir dire; the judge does. And you can submit questions you want the judge to ask. The judge may or may not ask those questions, but it is a much shorter period of time because they don't get into it as much, and it's very much, can anybody not be fair? And
anybody know these folks?
Yeah. And it's
And
arguable
who's going to
that
tell a federal judge sitting up,
I was about to say.
up on high on the bench with his black robe on, well, Judge, I just can't be fair. Well, even if I tell you to be fair, can you be fair? Well, if you tell me to, sure.
And anybody who's not been to federal courthouse, they're pretty intimidating places, and the judge's bench is about 10 feet tall. So I mean, you're looking up at this judge like he or she is God. So it's pretty intimidating.
Yeah, you're getting asked these. I mean, the questionnaires are not really tailored to the case. I mean, like you said, we'll talk federal. I mean, federal court, the lawyers, it varies by judge a little bit. For the most part, the judge is the one conducting the questions to the jury. And we should talk a little about the rationale for that, I think, in a second. But the way that works is the lawyers beforehand have tried to submit what they want to be asked. The judge and his law clerk have gone back and probably rejected most of those, or figured out that they feel like they are already asked in one of the stock questions, and that doesn't need to change. Then they'll just ask those questions, and if they're I think many judges will allow a few particular follow-ups if there's a juror that answers something that raises a question, and then give the lawyers a chance to ask, or the judge will do the follow-up. But for the most part, it goes by much more quickly. But I don't know, from a what is the reason that one is better or worse than the other? What are some of the justifications for that versus the more traditional state court?
I will say, I think the lawyer-conducted voir dire is superior, period, because you're going to get into people's real feelings about things much more than you can get from a judge just asking kind of stock questions from the bench. People aren't going to talk. I mean, that's the hardest thing with voir dire when you conduct it, is getting people to talk and share their feelings. Because, I guess we got to talk about the purpose of it. I think the
all
only
50
advantage
strangers are in a room.
The only advantage of the judge doing it is it's more efficient time-wise. But it does not reveal people with biases in the same way that lawyer-conducted voir dire does, which is the point. You want a fair trial, and that's what you're trying to get.
I've got sort of an example just to help everybody understand sort of what we're trying to ferret out and how we might do it. This is from a criminal case, so we're not giving away any of our secrets.
That's right, secret sauce.
But one of the big things in a criminal case.
This is your criminal case that happened.
Yeah. Well, no, it's right. I was offended. I was not.
Surprise.
One of the things we always talk a lot about in voir dire is the burden of proof. In civil case, it's more likely than not, which some people have a hard time with. And in a criminal case, it's beyond a reasonable doubt, which people who may have a bias against criminals may not realize how significant that burden really is. And so identifying people who either don't understand it or aren't going to be able to adhere to it is very important.
It's fundamental to the system.
So the voir dire on that goes sort of like this: is that Stephen, and you're talking to a juror perhaps that you've selected, and you've got eye contact. And Stephen, I want you to think of the person in your life. It may be your father, maybe your grandmother, grandfather, whoever it may be, who is the most trustworthy person that you can think of. And who is that person?
Oh, it's my grandmother.
Okay. Well, I want you to imagine that your grandmother has been accused of shoplifting at Publix.
Outrageous.
What's your first reaction to that?
She shops at Kroger.
Well, I mean, no, she loved the Publix, but yeah, outrageous. I mean, that's
it's like, there's no way that's true,
right? Yeah,
and like, no, Stephen, it is true. I'm telling you, it's true.
You're gonna have to prove it to me.
You're gonna have to prove it to me. Yep. And what's it gonna take? Well, if I have somebody off the street come in and tell you, are you gonna believe that person?
No, my grandma's, Ma, she's not going to, I'm not just going to believe somebody off the street that's going to say that. Yeah, I need more than that.
You're going to require and need a lot of evidence.
I need the video I need video footage.
Well, and it may be video, but you're going to need evidence that convinces you that this person, who you know to be trustworthy and honorable and a saint, committed a criminal act.
Right.
And that is the same burden of proof that the law requires, the same benefit of the doubt that the law requires you give this defendant. Does anybody have a problem with that? And it's very effective.
Yeah.
It's versus, is anybody going to have an issue applying the burden of proof in this case, which is beyond a reasonable doubt?
Right, exactly. Right. It's like, huh?
Yeah. What did you just? I mean, we just throw these words out like beyond a reasonable doubt,
Right.
clear and convincing, preponderance of the evidence. I mean, the chance for the lawyers to explain that, to give examples like this, I mean, that is the value in getting to the heart of whether or not these folks are qualified.
So now we go to, as a lawyer, the purpose for voir dire. And everybody, this is not uniform. Everybody sort of sees it a little bit different of what you're supposed to be doing. What I think voir dire is about is first and foremost, eliminating the jurors that you're going to be against you and fleshing out that bias. That's the most important thing, because if you can kick those people off, whether it's with your own strikes or strikes for cause, and we'll get back into that in a second, then that's good for your case, right? The other thing that you're trying to do is go ahead and lay your foundation for your case. And so, like Andrew just said, having that back and forth for a criminal case, it puts the jurors in the mindset of how they should be viewing the evidence in the way that, as a defense lawyer in that situation, would want them to be viewing it. Look at this person as your meemaw, not as you assume it's criminal and they probably did something wrong. So it's giving that perspective. And that's an interesting thing, because the jurors can talk back and forth and they can raise issues. And sometimes the vibe in the room is not what you want the vibe in the jury room to be.
Yeah.
And we had that recently, and they started talking about.
But the benefit of even that is it allows you to potentially get those jurors struck for cause.
Right.
So in my scenario, it's quite possible that somebody would say, well, obviously I know he's been arrested for something, and so in my mind,
right,
I don't think I could give him that benefit of the doubt. Well, he's just said I can't abide by the burden of proof. By law, by definition, he's not an appropriate juror. He may be appropriate for another case where a civil case or something like that.
Right.
But he's not going to be an appropriate juror for that criminal case, which is fine.
And
Absolutely.
so let's go ahead and we keep saying these words. Let's talk about what they mean. So you have strikes. You have strikes for cause. You have strikes for hardship, and you have peremptory strikes. So a hardship strike is if the judge strikes the juror because, let's say, there's somebody who has to take care of their, a special needs child, and there's nobody else who can do that. They will be excused from jury duty at that phase for hardship. It could be before that, but that certainly is the discretion of the judge to do.
And sometimes that doesn't come out until they start to hear, oh, this is going to be a 2-week trial.
Right. Yeah. Is there anybody who can't sit on this for this long? And there's usually a lot of like, well, I've got to work, and that's not enough. And then
No, jury duty it's inconvenient. I mean, it is I guess not a prescription or a conscription, in a way, in the same way that the draft is, we don't draft the military, but jurors are drafted, and it is a civic responsibility. So if everybody could get out of it for just work or ordinary hard, it is ordinarily hard. There's ordinary hardship.
You expect some hardship. It's not necessarily, doesn't have to be easy, but there are some hardships that rise to the level of you get out of the jury duty. But the ones we're really talking about are strikes for cause. So strikes for cause is like what Andrew was talking about. If a juror says they cannot abide by the law, essentially, if they say, I cannot apply this burden of proof because I want a higher burden of proof or a lower burden of proof, that is something. If they are going to say that, then they can be struck for cause. What we see a lot is if someone is biased one way or the other. Is the plaintiff starting off, like if this was a race, is the plaintiff starting off behind the defendant? And it's like, I've already kind of identified with the defendant more. That sort of thing. Or maybe they know one of the witnesses, which is not necessarily disqualifying, but what we see a lot if we have doctors and we're in a small enough town, like this doctor treated you for this, something way back when, would you give this doctor's testimony more weight because of your doctor-patient relationship? And if the answer to those is yes, then they're biased in some way. And bias does not mean a bad bias that we normally think of. It just means they're leaning towards one side or the other.
Or there's a prejudgment, a prejudice.
Right.
Prejudice, yeah.
And which, again, sounds like an ugly word, but trust me, we want someone to say, hey, we know that the charge for this is kidnapping, and I had a family member that was kidnapped, and I'm just not going to be able to put that aside.
Right.
You know, we want people to reveal that sort of bias or prejudice or whatever you want to call it.
And that leads to having a fair and impartial jury, because that's what you want.
The jury is supposed to come consider this just the evidence that's before them, applying the standard of proof, applying the judge. But if they come in there having already made a decision or already being with the plaintiff or with the defendant, I mean, you talked about that, somebody has a head start. That is not a fair trial. And that's what it's all about, is getting to a fair trial.
Right. And so just because somebody says, you know what, I don't think I can apply that standard of care, that's not the end of the story.
Yeah.
The judge or the lawyer can try to what's called rehabilitate that person. Just says, listen, I understand that you would have trouble with that, but at the end of this case, if the judge tells you that you got to follow the law and you're going to get this instruction and that's your duty, can you could do it then, couldn't you? And a lot of times, especially if the judge asks that question, the person will be more inclined to say, well, yeah, I can do that. So as lawyers, if we have somebody who's showing bias against our client, we need to get some more things. If it's just a feeling of the moment, no, I don't think I'd have trouble doing that. That is one thing. If it's a deeply held or long held feeling, that is more likely to cause the person to be struck. So we will ask them, it sounds like you feel very strongly about this. How would you describe it? He said, yes, I feel very strongly about this. And, is this a feeling you've had? And we get this a lot we don't like lawsuits. You don't like lawsuits and plaintiffs bring lawsuits. Is this feeling you've had for a long time? Oh, yeah. I've had this feeling a long time. And, since you've had this for a long time, you feel so strongly, in just a couple of days of this case, even if the judge instructs you to do otherwise, would you be able to set aside these feelings?
That you've held for a long time?
Yeah, and then they say, no, I don't think I can just set them aside. I'll do my best, but I can't set them aside. Okay, then you have a record that shows this person has a strong enough bias or prejudice against one of the parties that they should not be part of the jury. And that, as lawyers, we really try to utilize that, because if we can get our quote-unquote worst jurors struck for cause, we don't have to use one of our peremptory strikes. Judges don't like to do that. Judges
know that's what the lawyers want.
Mm-hmm.
I mean, it's no secret.
No,
and the judges just want an efficient process where they don't lose too many jurors and have to call more.
The judge doesn't care in terms of how the juror feels about a particular issue, other than them being fair and impartial. But they're not particularly worried that this person seems more like a plaintiff's juror and this person seems more like a defendant's juror. As long as that person can be fair and impartial, that's where the judge's concern ends, which is why it's important for the lawyers to have the chance to do this for cause argument, because you only have limited peremptory strikes.
Right.
Unlimited for cause strikes.
And typically, each party, if it's a two-party case, will have 6 strikes. And so the thought is that there will be 12 jurors struck, and so they'll say, all right, you're striking from the first 24 jurors that make it through the process, and each party strikes 6, and what are you left with? 12 jurors. And that's ultimately how the jury comes to be.
Yep. And then you have the alternates, which is in case a juror is excused in the middle of trial or something happens, they get sick or ill, or turns out they
just don't show up.
Yeah, or just don't show up.
Right.
Had a debilitating bias that doesn't come out till halfway through. You have these alternates, they can step in. They hear all the evidence, but unless one of the actual 12 jurors is unable to serve, they don't deliberate with the final juror.
Now, in Georgia, at least every case I've tried in Georgia, we use a silent strike system where there's a piece of paper with those 24 potential jurors on it, and the plaintiff goes first and goes through and marks his first strike. Then the paper's passed to the defendant. They mark their first strike, and that goes back and forth. And then at the end of that, the judge calls out who the jurors are going to be. In California, again, they do it differently. They have the panel in the box, and the first one will stand up, and the plaintiff will basically say, "Judge, we accept this juror," or "Judge, we move to strike this juror for whatever," and then the defense has their turn. So that's done right there in front of all the potential juror members.
But they don't know who struck. They don't know which side struck who.
Yes, they do. Because the plaintiff lawyer that stands up and the plaintiff lawyer says, we'll accept the jury.
I'm sorry. I thought you were talking about, yeah, they do in California.
In California,
I'm sorry.
they find it, but in Georgia, the jurors don't know who is striking who.
Right.
So one less way to potentially get sideways with a panel.
And last thing we'll talk about, we're running out of time, but you can strike jurors for a lot of reasons, but you have to have a reason that's not based on someone's race, nationality, or gender. And so,
and depending on where you are, a host of other protected characteristics. But yes.
Yeah. And so, if you have that, what happens, I think most commonly people challenge is on race, and there are Supreme Court rulings on that you cannot strike some because of race, and if someone.
The Batson case. Yeah.
The Batson case, yes. And so you make a Batson challenge named after the Supreme Court case. And when you do that, whoever makes it, the other side has to explain why they struck these people who, if they strike all 6 of their strikes are African Americans, and maybe they didn't speak up during voir dire, you have to give a reason. Well, what did they say or do that make you strike them?
Other than their skin color.
Yeah, their skin color. And it's...
And so the plaintiff, the party moving for the Batson, or making the motion under Batson saying this was an improper selection because it was based on race, that you just have to make that the prima facie showing, the first showing that the other party has struck, out of the 6 jurors they struck, 5 women were struck prima facie.
Yeah.
5 of them were women, and that violates Batson. Then the burden shifts now to the party that you were accusing of violating Batson, and they have to come up with a non-pretextual reason for why it is that they struck those people. I didn't like the way they. I mean, it doesn't have to be like a good reason in terms of like they could say, well, they just kept looking at me, and I just got to I got the facial reactions that I were seeing indicated to me that it's not going to be a good juror. I mean, it can be something as stupid as that. Then the burden shifts back to the party who made the challenge to show that's a pretext.
Right.
Actually, that you're saying that, but that person didn't speak up. That person actually didn't do anything like that. And then the judge has to make the decision about whether or not. And then if the judge says yes, this was improper. Depending on the process, there can go a lot of different ways, but usually you've got to redo the process of the selection all over again.
So there is a lot of moving parts. If you have jury duty and you just get up there and you're just sitting there, you don't realize it is like the duck on top of water. Looks like there's not much happening, and those feet are moving nonstop. So
kicking.
Anything else, guys, on voir dire before we wrap this one up?
I don't think so. I think it was a good discussion. Thank you, guys.
I think so too. And I hope everybody listening agrees that lawyer-led voir dire is superior in a lot of ways.
That's the way you take away.
That's the takeaway.
Obviously.
Yep.
Andrew?
Yes, sir.
You going to sign us off with your normal terribleness?
Yeah. All right. So what do you call a Viking who's lost his boat?
What?
A hiking. Oof. Oh, come on.
And on that note, we're going to wrap it up. This is Justice for Y'all. Tune in next time.
A delight.
Thanks for listening to Justice for Y'all, hosted by the attorneys here at Bowen Painter Trial Lawyers in Savannah, Georgia. If today's episode resonated with you, or if you find yourself needing legal guidance, remember, we're just a call away. You don't have to work through the difficulties of your situation alone. Visit our website at bowenpainter.com, that's BOWENPAINTER.com, or give us a call at 912-335-1909. We're here to serve you with the dedication and warmth only true Southern hospitality can offer. Thanks for tuning in, and don't forget to subscribe to our podcast on your favorite platform so you don't miss an episode. And tell your friends and family about us if they're ever in need of some legal insight. Take care, and remember that at Bowen Painter Trial Lawyers, we're committed to justice for y'all.